Center, and today you have joined us for our webinar on higher education accommodations and student loan forgiveness. We figured it made sense to do it in September since some people are either currently going back to school or thinking about applying to go back to school. So we'll be covering these two topics today. And really quickly, I do want to let you know that we will be posting the slides and the webinar recording on our website. So if this is something that you want to share with others, or if you missed something, we will be posting it on our website. I am going to try to leave some time for questions at the end of the presentation. Please feel free to type them into the question box. If there happens to be a problem with any of the sound or you can't see the slides, please again just type that into the question box and we will go from there. Okay, so first I do want to give you guys a little overview of the CLRC. I know you're probably already familiar with us, but we are a program of the Disability Rights Legal Center, and we provide confidential services in both English and Spanish, and we do also have a language line for people to call in if they speak a language other than English or Spanish. And one really important thing to keep in mind is that we do focus on an education model. That's how the CLRC is running. So, we generally don't represent clients directly or provide legal advice, but we try to educate people about what their rights are and what laws might apply to their situation, and then try to provide some referrals to either other organizations or attorneys that might be able to assist them further. One other really important thing to keep in mind is that CLRC services are free. We are a 501c3 nonprofit, so if any of the presentations that we provide for you or any of the other services that we provide are useful to you, we would really appreciate it if you were able to make a tax-deductible donation on our website, which is disabilityrightslegalcenter.org. But, our webinars are free, as is our telephone assistance line. So I mentioned that, I will try to leave some time for questions at the end of the presentation. If questions come up that I am not able to answer, or if you're thinking about the material later on and a question comes up later that you didn't have a chance to ask, please feel free to follow up with us on our National Telephone Assistance Line. The number is here on the slide, 866-843-2572. It's also 866-THE-CLRC. We also have an online intake form which might be faster. So that is located at clrcintake.org. So you can either give us a call, you can submit an online intake. We certainly have received emails, letters, and faxes, but we usually try to direct those people either to our line or the online intake form. And then we'll be able to follow up with you on any of the questions that you might have. So let's go ahead and get started here talking about protections in higher education. So it's important that students with cancer-related disabilities understand their rights and responsibilities when they're preparing for college, college-level courses, and beyond. So there might be many protections that exist for students of all ages. Students do have more responsibilities at the college or graduate level to request and assist in identifying accommodations that they might need. So many of the protections that are available for younger students, such as a free appropriate public education, also known as FAPE, and the Individuals with Disabilities Education Act, IDEA, those do not apply to college-level education. So the following information that I'm going to share with you can help students with disabilities prepare for and succeed in college classes and beyond. So there are a few main laws that I'm going to be discussing today. The first is the Americans with Disabilities Act, or the ADA, which is a national law that offers certain protections for people with disabilities. There's also Section 504 of the Rehabilitation Act of 1973, and that also provides protections for people with disabilities. So first, Section 504 of the Rehabilitation Act. Section 504 is a federal law that was designed to protect the rights of individuals with disabilities in all programs and activities, including educational programs, that receive federal financial assistance. And so in the school context, that includes from the U.S. Department of Education. So recipients of this federal financial assistance include public school districts, institutions of higher education, public or private, vocational schools, and other state and local education agencies. So essentially, it prohibits discrimination against students with any disability or with disabilities by any school with federal funding. The Americans with Disabilities Act, on the other hand, the ADA, also prohibits discrimination against students with disabilities at the college level. Title II of the ADA covers state-funded schools such as universities, community colleges, and vocational schools. Title III of the ADA covers privately funded colleges, vocational schools, and private entities that offer certain educational exams and or courses related to occupational certification. So depending on what school you go to, you might be covered by both 504 and the ADA, or maybe one or the other. So the ADA is another opportunity for accommodations at school if you have a disability. And I'm going to go into more detail in a bit about what exactly it means for the purposes of these laws to have a disability, because not everyone thinks about cancer necessarily as being a disability. So what if you go to a private school? Section 504 only applies to schools that receive federal financial assistance. Private schools that do not receive government funds are only covered by Title III of the ADA. So as a result, these institutions may be more limited in the types of accommodations they might be able to provide depending on their available resources. Regardless of these limitations, however, they are still required to accommodate students with disabilities. So as I mentioned, you're going to have to take a look at what type of school you go to and where their funding comes from to figure out, okay, is it 504 or ADA or both? So first things first, because the ADA and 504 have a lot of complicated language, I want to make sure that we're all on the same page with respect to the law's specific definitions. So it's important to understand the law's definitions in order to know whether or not you're actually protected as a student. So what is a disability for the purposes of the ADA or 504? Well, there's three parts to that definition. So you have to have an impairment. That impairment has to limit a major life activity, and that limitation has to be substantial. So I'm going to go through each of those and break those down. Obviously, a physical or mental impairment is pretty self-explanatory, but generally, physical or mental impairments should last for more than 6 months, but some schools might still accommodate a temporary impairment. So what's a major life activity? Well, a major life activity is basically any of the major things that you do on a daily basis as part of your life, including walking, talking, breathing, eating, caring for yourself, any of the activities of daily living, reproduction, sometimes working. So it's sort of any of these major things that you think of as necessary to your daily life. So you would have to have some sort of impairment that would limit one of these major life activities, or one or more of these major life activities, and the limitation would have to be substantial. So one thing I do want to note is that when we're talking about the impairment, a physical or mental impairment, it doesn't just have to be the diagnosis or the illness itself, but it can also be the side effects of treatment. So maybe, the cancer itself isn't necessarily causing a substantial limitation on a major life activity, but maybe the effects of the chemo are. That would still potentially qualify you. So a substantial limitation is an inability to perform a major life activity in the way that an average person in society would be able to perform it. So, some of the factors that they look at to determine whether or not a limitation is considered substantial would be the nature and severity, the expected or actual duration of the limitation, and then also the impact of the disability on life. So, one example that I like to give would be maybe the difference between just breaking your arm or spraining your wrist compared to, potentially losing an arm or severely damaging, the nerves in your hand. Obviously, one is going to last much longer or is potentially permanent versus, maybe if you only sprain or break something, you'd only need a cast or a sling. So let's say that you do have a disability according to that definition. In order to be protected as a student would have to first be disabled according to the definition that we just went over. You'd also have to have a record of the disability, or you'd have to be regarded as having a disability. So, sometimes I think we probably all know one or two people who are maybe wouldn't refer to themselves as a hypochondriac, but sometimes people like to self-diagnose. You would actually have to have some sort of record of the disability, so some sort of medical certification or notes in your medical file that shows that you actually do have a disability, or you'd have to be regarded as having a disability. So one way that sometimes comes up with respect to cancer patients would be if someone has gone through their treatment and they've lost all of their hair, someone might take a look at them and say, oh, well, this person's clearly sick and they maybe have a disability, and so we're going to treat them differently. The fact is, maybe that person can still perform everything that they were doing before, they just simply no longer have all of their hair. So that would also be something where you could get protection under one of these laws if someone is regarding you as having a disability, even if you don't, currently have one. And cancer is usually considered a disability under the ADA, but it is determined on a case-by-case basis. So if you're deciding whether or not to go back to school or to apply to college or graduate school, you might want to know about how you'd be protected during the admissions process. So both of these laws ensure that students with disabilities may not be denied admission to any school on the basis of their disability. A college or university may not use discriminatory methods to screen out or limit the number of students with disabilities that might apply or be admitted. Furthermore, the actual application cannot ask applicants if they have a disability. Once a student has been admitted, a school can ask whether a student has a disability on a confidential basis to determine if accommodations might be needed. Students are actually not required to disclose their disability if they don't require accommodations. So if you're never going to need any sort of assistance while you're in college or graduate school, you never really have to tell anyone that you have a disability or that you have a history of having a disability. However, students must self-disclose in order to receive accommodations. So if you are going to need some sort of change to the environment or, flexibility with respect to your classes, and I'll talk more about accommodations as well. But if you are going to need or request any of those things, you would have to disclose the fact that you have a disability. So students may choose to discuss their needs privately with the Disability Services Coordinator or some other, similarly designated individual, rather than disclose their disability on a form they receive from the school. So it might be the policy of the college or university that maybe they just send out a form to everyone who gets admitted saying, do you have a disability, and if so, do you need an accommodation? Here, fill out this form. The student probably wouldn't be required to fill out that form if they're not comfortable. They could probably just talk to someone in the Disability Services office or one of the dean's offices if they're not comfortable with sharing that information on just some blanket form. So the other way that students are often protected during the admissions process is that there is an opportunity to explain how your disability has affected your performance. So sometimes a student's disability may affect his or her transcripts or qualifications when applying to college or graduate school. If this situation applies to you, there may be a few options available. So first, some schools allow for extra documents to be submitted with your application. So these documents are sometimes referred to as addenda. An addendum gives you the opportunity to explain why a particular transcript or entrance exam may not be entirely reflective of you as a student or your academic capability. And some examples of when an addendum might be appropriate are, for example, an entrance exam score, so GRE, LSAT, SAT, if it doesn't accurately reflect your academic potential. If you receive an exceptionally poor grade in a particular course, if there's a long gap in your previous school attendance, obviously excluding summer, or taking extra time to complete a particular grade in high school. So something like that might make sense to include an addendum so that you can explain why it took you so long to complete that grade in high school, or why you got such a poor grade in a particular course. Second, you may consider talking about your disability and how it has affected your academic performance in a college personal statement or some other type of essay question that often is required when applying to either undergrad or graduate school. So some students choose to write their college personal statement about a life-changing experience such as having cancer and how that has affected their career goals. On the other hand, some students may not feel comfortable discussing their personal experiences, especially if they don't wish to tell their school that they have a disability. So it's certainly not required, but that can be one way to sort of explain away some of the issues that might potentially hinder them from being accepted into the school. So students with documented disabilities might also apply for accommodations when they're taking college board exams, and so that includes the PSAT, SAT, SAT subject tests, or AP advanced placement exams. So this is sort of another way that people with disabilities or students with disabilities are potentially protected in the application process. So they shouldn't be denied entrance to college or graduate school just because they are, unable to take one of these exams the same way that someone without a disability is. So to be eligible for accommodations, usually a student has to be able to document the fact that he or she has a disability. They have to document the degree to which the disability impacts activities, and then also the need for the specific accommodations requested. All requests must be approved by the College Board Service for Students with Disabilities, SSD, regardless of whether the student receives accommodations at school. So, if you're a senior in high school and you're not getting accommodations at your high school, but you actually do have a disability and have a need for accommodations for one of these exams, you're not prohibited from requesting an accommodation just because you don't have that at school already. One important thing to keep in mind is that College Board approval for accommodations can take up to 7 weeks, and the deadlines for accommodation requests may be earlier than regular exam registration deadlines. So if you think that you're going to need an accommodation when you're taking the GRE or the SAT, then it's really important to request that far enough in advance, because otherwise you might miss out on being able to take the test at the time that you want to. So, what are some examples of test accommodations? Extended time, extra breaks, a private room, screens to block out distractions, maybe a specified time of day or, over the course of multiple days. And it all has to be linked to what type of disability you have and how that disability is impacting your activities. So, a person who has diabetes might be able to request extra breaks so that they can have snacks or check their blood sugar, but it might not necessarily make sense for them to request an accommodation where they take the exam over multiple days, if that's not really linked to what their disability is. So there does have to be some sort of relation between the accommodation that you're asking for and what your disability is and how it impacts you. So let's say you get through the application process and you also, have passed the exams with flying colors and you get enrolled into a college or graduate school. Once you're admitted, at that point you also might want to know how the ADA and Section 504 would protect you. So generally speaking, colleges and universities are required to make reasonable accommodations for students with disabilities. These types of accommodations might also be called academic adjustments. And the accommodations may include modifications in the school's practices, their policies and procedures, or provision of auxiliary aids and services. An appropriate accommodation is determined through an interactive process based on a student's disability and their individual needs. Now, a school is not required to make any adjustments that would fundamentally alter the nature of a service, program, activity, or would cause an undue financial or administrative burden. A school is not required to waive or lower essential requirements, nor required to provide accommodations to students who do not disclose that they have a disability. So, if you apply to Harvard and you really, regardless of whether or not you had a disability, you really didn't meet any of the normal requirements that there are in order to be enrolled in a school like Harvard, they wouldn't have to lower their admissions guidelines just because the person has a disability. They might be able to, and the same as once you've started school, so they wouldn't necessarily have to completely change the nature of a class, but there might be some sort of modifications that they would be able to do that would make it easier for you to complete your work and successfully complete your classes. So some examples of reasonable accommodations in higher education would, again, be, extra time on exams. Sometimes note-taker services are available for people who are, maybe having cognitive issues where they're not able to focus so much or maybe can't really multitask during a class. Also access to adaptive technology. So there might be some, software that makes it easier for people with disabilities to get access to maybe the textbooks are difficult to deal with. It's all going to depend on what your specific disability is and how it affects you. But these are just a couple examples. Another example that we see, somewhat frequently here with the CLRC is the issue of additional absences. So sometimes classes will say, oh, you can only have 2 or 3 unexcused absences before it starts affecting your grade. Now, if somebody is going through treatment or has a sudden relapse of, whatever issue that they're facing, obviously some of those absences can be, it's easy to rack up quite a few unexcused absences or even excused absences. Sometimes there are limits on those as well. So, you know, that can potentially be an area for a reasonable accommodation as long as the person is still getting his or her work done and, you know, taking tests and quizzes that are required. You know, that might be one way that someone could ask for a reasonable accommodation if they know that they're going to have to be missing class. So who has to offer accommodations? All school programs, including extracurricular activities, must be accessible to students with disabilities. Further, if a college offers housing, it must provide convenient and accessible housing to students with disabilities who need it. The housing must be provided at the same cost as it is to other students and must be comparable to the housing provided to other students. A school may not charge a student for accommodations that he or she needs, and a school may also not charge its students with disabilities more tuition or program costs than it does for other students. So, you know, if you're in a wheelchair and you need wheelchair accessible housing, they wouldn't be able to charge you more for your wheelchair accessible dorm room than they would be charging anyone else for, you know, the other types of dorm rooms that are available. So, you know, let's say you've been accepted into college or a graduate program, you have a disability that needs accommodation, you have some ideas of what type of accommodations might be necessary. So how do you go about requesting the accommodation? What is that process like? Most post-secondary educational institutions have an office or a designated individual, such as a disability services coordinator or access coordinator, who is responsible for coordinating accommodations for students with disabilities. Students can obtain information about the school's procedures for requesting accommodations through this office or individual. And if you're uncertain about who is responsible for coordinating accommodations, you can first try searching the school's website for disability services. This information might also be listed under health services or learning accommodations, student resources, or student services. If the school's website does not contain information for students with disabilities, you can try contacting the Dean of Academic Services, the Dean of Student Services, or even the admissions office to find out who is responsible for ADA accommodations. So while you will need to disclose your disability after you are admitted in order to receive accommodations, you can exercise some control over when and to whom to disclose this information. The Disability Service Office or Coordinator must keep information about your disability confidential and may not discuss your disability except on a need-to-know basis to provide appropriate accommodations or emergency planning and response. So information about your disability does not go into your school transcript or record. So, you know, it might be necessary for the disability service coordinator to talk to your professor, right? Because your professor, if he is the one proctoring an exam, he's probably going to need to know whether or not you need additional time or additional breaks. If the issue is emergency planning and you're living in a dorm, they might need to tell your RA, right, your resident advisor, or whoever's in charge of all of the people on your dorm floor. But they wouldn't be able to just blab about it to whoever they want. It should be kept in a confidential file, and there wouldn't be anything that would show up on your transcript. You know, there'd be no asterisk next to one of your classes saying, oh, well, she got a B+, but she was able to get extra time on the exam. None of that would happen. It's all considered confidential. So timing is a really important thing when it comes to requesting reasonable accommodations. It is very important to request an accommodation as soon as you know that you might need one. This will enable you and the school to plan accordingly. Some accommodations may require more time to arrange, and it is generally more costly or more difficult for a school to secure accommodations on its own notice. So, if, for example, you need an exam to be given, if you need extra time on an exam, for example, they would probably have to coordinate that with the professor or with the teaching assistant or with whoever else might be proctoring it to make sure that that person is available. If nobody's available, that might delay whether or not you can take the exam on the same day, or it could just basically lead to some logistical problems. The other issue is that waiting too long to ask for an accommodation might also mean that your disability affects your performance on a test or a project, and poor performance could ultimately result in your receiving a poor grade or having to repeat a class. And usually when you have to repeat a class, that means you also have to pay to repeat a class. If the need for an accommodation arises unexpectedly once you've started a program, or if your need for accommodations changes, again, contact your school's disability services office or coordinator as soon as possible. So, we've definitely received calls on the telephone assistance line here before from students who've said, I missed a whole bunch of classes, and then later on I tried to tell my professor that it was because of my cancer treatments, or it was because I was, feeling really ill because of my chemo, and then I had to miss the final exam, and I asked to take it again later, and, at a certain point, it's really important to let the professor or the school in general know ahead of time if you know that you're going to be out. Obviously, there are certain circumstances where things come up, you have no idea that you're going to have to miss class until the last minute, but at least if the professor or if the school is on notice, they might be more inclined to make last-minute accommodations if necessary. So again, it's very important to request accommodations if you know about the need before your performance is affected. Nobody wants to fail a class. Nobody wants to have to take a class over again. So if you can avoid that at all, try to be proactive. So accommodations, like I mentioned, are determined through an interactive process, which basically means that there can be some negotiation back and forth between the student and the school to figure out what exactly would be the best accommodation that would suit you and the school. So it's helpful to think about what types of accommodations might suit you, and also to put your request in writing. You should try to be as specific as possible so that all of your concerns can be addressed properly with an accommodation or modification. And additionally, the request should describe how your disability affects your participation in school and how your recommended accommodations can help you. Schools might differ in the documentation that they require to show the need for a reasonable accommodation, so you should check to see what type of documentation your school requires and have it ready to submit with your accommodation request. So an example would be a signed letter from your treating physician that verifies your disability and your functional limitations and suggests accommodations. Usually doctors are pretty good about being able to provide some sort of certification for this type of purpose. So what happens if you go through the whole process and your accommodation request is denied? Well, if your school denies your request for accommodations, or if you are dissatisfied with the accommodation that you receive, so maybe you've gone through the interactive process and they've really not given you enough. Maybe they've said, okay, we'll excuse 1 or 2 more absences, but anything beyond that, we're still going to have to fail you. If you're not satisfied with that, you might have access to an appeals process for reconsideration. So you can contact the Dean of Academic Services, the Dean of Student Services, or again, the admissions office to find out who's responsible for the ADA accommodations and also what the process is for an appeal. And then you can also consider talking directly to your professor or to another faculty member if you think that, going through the process yourself was not particularly helpful, because often professors, they want their students to succeed, so they might serve as, sort of an additional advocate for why you might need the accommodation that you requested. So what if you think that your school is discriminating against you as a person with a disability? All government-funded schools must have a grievance procedure for addressing discrimination complaints. If your situation cannot be resolved informally or by discussing the matter with the Disability Services Coordinator or other point person responsible for ensuring Section 504 and/or ADA compliance, you can follow your school's grievance procedures. One example of a school resource that would explain this information would be your school's student handbook, or you might also find this information on your school's website. If you go through the grievance procedure at your school and you're unhappy with the result, or if you want to pursue an alternative to those procedures, you can also file a complaint against your school with the Department of Education by contacting the Office for Civil Rights. One thing that's important to keep in mind is that you only have 180 days following the date of a discriminatory action to file your complaint. So, it's probably not necessarily a good idea to think about it over the summer because, if something happens in the spring semester, you think, oh, I'm going to wait a little while and see how I feel about it. Just make sure that you keep in mind that you only have 180 days following the date of the discriminatory action. So you might not want to wait too long. So here are a couple of resources with respect to, accommodations in higher education, or also potentially discrimination against people with disabilities in higher education. We've got the U.S. Department of Education Office of Civil Rights, and then also the U.S. Department of Justice Civil Rights Division. And again, we will be posting the webinar and the slides on the website, so you'll be able to access these resources as well. So now we're going to switch gears a little bit. Let's say you've already gone through college or graduate school, and unfortunately you have student loans and you are struggling to pay them, just like many other people throughout the United States. Actually, student loans currently account for over $1 trillion of debt in the United States. And so while some students need to take out loans in order to afford college or graduate school, education-related debt can often take a long time to pay off and requires careful planning. It's often difficult enough to pay back student loans regardless of whether you have a disability or have had cancer or developed cancer. Obviously, an unexpected cancer diagnosis could make it even more difficult to repay some of the loans. So I'm going to go into a couple of the options that you might have if you're struggling to pay back some of your student loans. So if you're facing a situation where you think you might not be able to pay your loans, or if you're already falling behind on your payments, there are a few different options that you can look into. So keep in mind that you might be able to get a deferment or a forbearance regardless of what type of loans you have, federal or private. Total permanent disability discharge really only applies to federal loans, and I'm going to go into detail about each of these different options over the next few slides. So the first option for you might be deferment. If you're facing a temporary loss of wages or funds, you might want to consider requesting a deferment. A deferment is a period during which repayment of the principal balance of your loan is temporarily delayed. So in the picture here, we have someone sort of hitting the snooze button. That's basically what that is. During a deferment, you do not have to make payments. And depending on the type of loan you have, the federal government might pay the interest on your loans during that deferment. So the government may pay the interest on your federal Perkins loan, direct subsidized loan, and/or subsidized federal Stafford loan. So those are the three types of loans where the government might pay the interest if you are in a deferment. The government does not pay the interest on your unsubsidized loans or on any PLUS loans, so you're responsible for paying the interest that accrues during the deferment period, but your payment isn't due at all during the deferment period. So if you get a deferment for 12 months, let's say, you wouldn't have to be making any payments on the principal or the interest during that 12 months, but once the 12 months is up, all of the interest that accrued during the 12-month period would potentially be added on to your it's capitalized, so added to your principal balance, and then the amount you would have to pay back in the future would be higher. So some accepted reasons for deferment of repayment include inability to find work, a period of economic hardship, or a period of active military duty. To request a deferment, you'd have to contact your loan servicer, and your loan servicer is the one that will make the decision as to whether or not to grant you a deferment. Or there might be other limits on limits on how many deferments you can request. So, sometimes right when people get out of school, loans will be deferred, payments will be deferred for 6 months or so, and then let's say you graduate in May, so maybe you'd have to start paying back loans in November. Well, at the end of that 6-month deferment, if you still haven't found a job, you might be able to request another one, but it's really up to the loan servicer to determine whether or not they actually want to give that to you, or if you've already maxed out the number of deferments. So if you can't make your loan payments and you don't qualify for a deferment, your loan servicer may be able to grant you a forbearance. So with a forbearance, you may be able to stop making payments or reduce your monthly payment for up to 12 months. The problem here with a forbearance is that the interest will continue to accrue on your subsidized and unsubsidized loans, including all PLUS loans. So, whereas with a deferment, the government might be paying some of the interest on your subsidized loans, during a forbearance, the interest is still accruing for all of your loans. And so to request a forbearance, you'd again have to contact your loan servicer. And there are 2 different types of forbearances. So the first kind is probably the kind that is most common, which is where your lender decides whether or not to grant a forbearance or not. So you can request a discretionary forbearance if you have financial hardship, if you have illness. I've had to request them when there were issues with paperwork regarding my student loans, and they messed up, and so they said, okay, well, just don't pay for this 1 month, and then we'll figure it out over the next month, and then your payments will start again next month. But of course, it's not really a get out of jail free card, because the interest is still accruing while you have that forbearance. Now, the other type of forbearance requires that you meet certain types of eligibility criteria. And so if you meet the criteria for one of these, the loan servicer is required to provide you the forbearance. So if you're serving in a medical or dental internship or residency program and meet other specific requirements, they'd have to give you the forbearance. If the total amount you owe each month for all of the student loans you received is 20% or more of your your total monthly gross income, or if you are serving in a national service position for which you received a National Service Award, if you're performing a teaching service that would qualify you for teacher loan forgiveness, if you're a member of the National Guard, if you might qualify for partial repayment of your loans under the U.S. Department of Defense Student Loan Repayment Program. So these are for really specific scenarios. Most people who have student loans probably don't fall into any of those categories, except maybe the one regarding your monthly income. So for the most part, I think most people are going to be requesting either a deferment, which would be preferable, or a forbearance, and it's probably going to be at the discretion of your loan servicer for either one, whether or not they want to give that to you. Obviously, they'd probably prefer for you not to default on your loans completely, so if it seems like you might be able to, get things together and recover some of your income at some point in the future, it might make sense for them to give you the forbearance or deferment. So it's really just going to depend on your loan servicer and your particular situation. So what if you're completely unable to pay back your student loans? There might be another option, but again, this is for a very specific subset of student loan borrowers. If you borrowed certain types of federal loans to attend college or graduate school and you have a total and permanent disability, you may qualify to have your loans forgiven or discharged so that you don't have to pay them back. The federal government has a program called Total and Permanent Disability Discharge, TPD, and it applies to only very specific types of loans. So those loans are William D. Ford Federal Direct Loans, Federal Family Education Loans, FFEL, and or Federal Perkins Loans. So it's direct loans, FFEL, or Perkins loans. Those are the only ones that potentially qualify for a TPD, Total and Permanent Disability Discharge. The program also applies to individuals who have to complete a TEACH grant service obligation. So the TPD discharge only applies to federal loans that you borrowed for college. Private student loans borrowed from a bank or other financial institution are not eligible for the TPD discharge program. Private loans are not subsidized or regulated by the federal government and do not have the same types of discharge, deferment, or forbearance options that are available for federal loans. So, if you're in a position where you're thinking about applying for student loans or, are thinking that you might need additional student loans, usually it's a little bit safer to apply for federal loans as opposed to private ones because private loans might have higher interest rates, and then again, they're not covered by some of these other options that you might have. If you need a deferment or forbearance, you might still be able to ask your private loan servicer for one of those, but you certainly would not be eligible for a total and permanent disability discharge under this specific program. It's all going to be based on, whatever the promissory note is that you signed with the private bank or financial institution. So if you're unable to pay a private loan, it's a good idea to contact the private lender and find out if you can negotiate some of the debt or possibly come up with an alternative repayment plan. So before these loans can be discharged, you do have to fill out an application and provide information to the U.S. Department of Education to show that you are totally and permanently disabled. There are different ways that you can show that you're totally and permanently disabled, and so there's basically three main options. It'll depend on whether you're a veteran, so if you're receiving veteran disability benefits from a service-related disability that prevents you from working, or if you're receiving Social Security benefits like SSDI or SSI, or if you have some other long-term disability that prevents you from working, you can have a physician certify the fact that you are unable to work because of your disability. So for specifics on how to show your disability, you can go to the TPD Discharge website at www.disabilitydischarge.com, and I'll have that on a later slide, so don't worry about writing that down right now. And then you would click on application process to see what else is required. They have a 1-800 number. The website provides a lot of information. So, depending on your situation, you'll have to provide evidence about your Veterans Affairs disability, evidence about your SSI or SSDI determination, or a physician certification that shows that you have a disability that's expected to last for at least 5 years or end in death. So once you contact NELNET, that's sort of who's in charge of the TPD discharge through the Department of Education. Once you contact them, your loan payments might be suspended for up to 120 days while they're going through the application process. If they don't receive your application within the 120-day period, you will have to start paying your loans back again. So if your TPD discharge request is approved, you'll be notified by NELNET. Any loan payments that you made on or after you became totally and permanently disabled will actually be returned to you, and then your loans will be discharged. So if you were paying your loans, even though you were disabled, and then finally realized, okay, look, I'm probably not going to be able to go back to work, this is not working out, I can't make these payments. If you've been paying for a while, you might get some of that money back to you, or all of that money back to you, depending on when you became disabled. Depending on how you showed your disability, you may also be subject to a 3-year monitoring period begin from your TPD discharge date. So if that applies to you, you will have to continue to meet certain requirements to keep your loans discharged. So if the 3-year monitoring period applies to you, your loans will be discharged for the first 3 years after your TPD discharge. You do not have to make any payments towards your loans for those 3 years. However, you may have to begin repaying your loans again or fulfill your TEACH grant service obligation if during that 3-year monitoring period any of the following things happen. So if your yearly income exceeds the federal poverty guideline amount for a family of 2 in your state, regardless of your family size, that could potentially mean that you'd have to start repaying your loans. If you receive another direct Perkins or TEACH grant, if you receive a direct loan, Perkins loan, or a TEACH grant before your TPD discharge date and you do not return the entire amount of the loan within 120 days of the date you received it, or if your disability status changes for the purpose of any SSDI or SSI benefits you're receiving. So let's say, you get your TPD discharge approved, you're receiving SSDI, which is Social Security Disability Insurance, and, the Social Security Administration also has a monitoring procedure where they check back in to see, every 3 or 5 or 7 years to see whether or not your condition has changed. If your condition has improved and they no longer deem you disabled, that's something that you would need to report to NELNET so that you would potentially have to start repaying your student loans. So once your loans are completely discharged, the amount of the debt that is discharged does get reported as taxable income for the year that the loans are forgiven, in addition to any other taxable income that you have. So this could be a lot of money, which is kind of crazy when you think about it. So this applies to any discharged loan of $600 or more in a given year. NELNET will send you an IRS Form 1099-C, and you'd have to fill it out and include it when you file your taxes. If you're unable to pay the IRS the amount owed from your discharged loans, it might be best to contact the IRS and ask if they can negotiate a repayment plan with you. So although the IRS is not required to negotiate a plan for you, there may be different options available for individuals who cannot pay the full amount owed after a TPD discharge. So it's really important to remember that just having the loans discharged isn't the end of the story. You might still owe the government some money because they count the amount that is discharged as income. And so, if you're still earning a little bit of money, or if you're married and your spouse is earning money and you're filing jointly, depending on the amount of loans that are discharged, it could take you into an entirely new tax bracket, which means that potentially you might owe a lot of money if you have a lot of loans discharged. So the IRS does have an insolvency exception that applies to taxpayers who receive a TPD discharge. And a taxpayer is considered insolvent when the amount of taxes he or she is responsible for is much greater than the amount of assets that that taxpayer has. As a result, the discharge debt is not considered income for the taxpayer, and he or she does not have to pay taxes on the amount. But you would have to apply for the insolvency exception, and so you would do that by filling out IRS Form 982 when you file your taxes the year after your loans have been discharged. So there might be some relief with respect to having to pay taxes on the amount of the loans that are discharged, but it's only going to apply if you meet these certain criteria and you apply for this insolvency exception. So if your loans are reinstated before your 3-year monitoring period is over, you will again be responsible for repaying your loans or completing your TEACH grant service obligation. However, You will not have to pay interest that would have built up on your loans during the time they were discharged. So, if they were discharged for 2 years and then your situation changes, you wouldn't have to go back and pay all of that interest that would have accrued during that 2-year period. You may contact the Department of Education if you have questions about the reinstatement or if you believe that the determination was incorrect. So what happens if your TPD discharge request is denied? If your application is denied, you will be notified of the reasons for the decision. Then you will have to continue making payments towards your loans. Your notification letter will also include information about how to request a reevaluation of your application. So here are a couple of resources that are useful with respect to student loan forgiveness or deferment or forbearance. So the disabilitydischarge.com, that is through the U.S. Department of Education. That's where you can learn more about TPD, the total and permanent disability discharge. And another really good resource that we like to refer callers to here is the Student Loan Borrower Assistance, which is a project of the National Consumer Law Center. And so that's just studentloanborrowerassistance.org. And they have information not limited to people with disabilities, but it's information about student loans in general. Okay, so at this point I'm going to end the recording, but I'm happy to try to answer any questions that you might have.